My name is Jay Thomas, and I'm a member of the law faculty at Georgetown University. It's always great to come back to GW because I started my academic career here and got an LLM degree here before that. So I actually was on the faculty here, and we actually had faculty meetings in this room on occasion all those years ago. A lot of bad decisions made in this room. They gave me tenure, so obviously I don't know what was going on. But it's great, it's wonderful to be back, and it's wonderful especially to see Judge Newman today, who I have the pleasure of introducing. So my first encounters, of course, like many of you in the patent field, with Judge Newman was in law school. I remember started reading some of your opinions, and it was 1990. And I was looking to see what opinion was the first I read from you, and it was Pollack v. Riscala. So that's a case that held, if you're the first inventor and you sort of stop work for a while, but then you resume work before someone else does, then you still maintain your status as the first inventor. And I was just really struck reading that opinion after all these years, the degree of consistency throughout your work, the concern with innovation policy, and also someone who had actually really done it as a PhD chemist and as an actually practicing patent attorney who had come to the bench and was able to bring those recognitions of the reality of the industrial and innovation processes. There's three major case books in the patent field, although there's some more of them coming out now, the online version, so it's really diffused. So I looked at sort of the top 5 as I could discern them, because we're coming up with a new edition for our book. And I was thinking like, well, who's actually got the most opinions in these books, right? Judge Newman, it may not surprise you, she's the leader. You've got the number one, you're the number one author of opinions that different casebook editors have assembled. So it's your work, it's your written expression that is getting people excited about the patent law field and how they're learning patent law. So it's really just extraordinary pleasure to think about Judge Newman's history with the Federal Circuit. Obviously, she was the first judge actually appointed to the Federal Circuit. There were predecessor judges from predecessor courts, but she was the first judge in, and actually she had worked previously helping to set up the court. So it's really her vital pulse that has driven this court through its entire history. And I think these concerns are overblown, but one thing about the Federal Circuit, as you know, is that it's the Court of Appeals that hears patent appeals for the entire country. So there's concerns, which I believe are overstated, that there's not that percolation of ideas and thought between the 2nd, 5th, 7th, 9th circuits, and all the appellate courts aren't going at it, to present more of this rich tapestry for the Supreme Court. And I think probably when I've heard that, of course, one answer to me has always been, well, what about Judge Newman? Judge Newman's the one who's actually sort of institutionally representing that voice because she brings a deep sense of wisdom and erudition. She has the history of the court and also this knowledge of innovation in mind. So I think she's the one, the great dissenter. I think it's the second Justice Harlan and Judge Newman are the great dissenters of the history of American law. And just one last thing I'd like to say about Judge Newman is what a friend she's been to the law schools and to the intellectual life of the legal community. Obviously, she's here today. I know she's been a good friend not just to GW and my school, Georgetown, but to the law schools generally. And sometimes I find out later, they don't tell me, but I'm always very grateful for the clerks that you've hired who are my former students. And just the legacy of your clerks alone would be a remarkable achievement, even if you set everything else aside. So Judge Newman, I could go on for a little bit. We've got an hour. And I just, again, want to welcome you to the lectern, and thank you so much for coming today. Let's have it around for Judge Newman.
Why don't I try sitting here? Okay. Is this working? Can you hear me all right? Well, I'm not sure I know what to say after what Jay has been saying, but I'm so proud of our court and of the law clerks. I'm so pleased that 2 of my clerks are here today, paying attention to another area. And the curious thing, when vaccine law first sort of came into came into being, and it was decided, now what are we going to do when the Childhood Vaccine Injury Act was enacted? And it was agreed, without anyone really paying much attention, that all of those appeals would come to our court. It has been proposed in the past that various areas, when it's pretty clear that it would benefit from national uniformity, might come to the only national court that we have on the appellate level. And more often than not, there is a clamor against it, such as a recent proposal to put all copyright appeals in our case. And the Ninth Circuit and the Second mounted a vigorous and successful campaign against it. But when the vaccine appeals came up, the solitude, the silence was somewhat deafening. And so we've had the opportunity over these last few years in our court to keep an eye on what's happening in vaccine law. Of course, the things that reach us through the liability phase, the injury aspect, are different from what might happen. But every once in a while, some very interesting aspects of the science, the technology, the developments in the biotechnology that's happening in the vaccine field comes up as a matter of determining whether, in fact, a particular injury was caused by the vaccine or something else. And so here we are now, because I think it's pretty clear to all of us that the potential science, the biology, the societal impact of what's happening in research, in scientific development, in vaccines is so powerful and so potential that it is, I think, really the dominant area for us to be concerned with. And therefore, here we are, come together at an extraordinarily opportune time. At the same time, the question arises, just as it arose in our court with questions of causation, that how about the patent system? How about the principles of property? There is so much that we're starting to see in the vaccine area. After all, is it obvious to try whatever it is that we're trying in vaccine development, and a few $1 billion later, we succeed, and now what? How do you recover that investment? This is what the intellectual property system is really all about. It was behind the nation a couple of centuries ago when it was seen throughout the world how these principles of proprietary rights affected innovation, creativity, industrial growth, particularly as the so-called Industrial Revolution was coming to life. And with these new aspects of technology in the vaccine field, we need to understand, we must understand, not just how the present law applies, which is what we have to know, and I think that Jay will tell us some more about that this morning, and as we have been hearing over the last day or two, but also to understand if it's not optimum, if it's anything less than optimum, it's in our hands. We can fix it. I think back to when we thought to create the Federal Circuit, and it looked as if there were things that needed fixing. Whether, in fact, now, 40 years later, the fix that we picked was optimum, after all, is a different story. Certainly something we need to have in mind. But the opportunity for this, in a sense, narrow field of technology, of science, but enormously encompassing in the scope of the scientific principles and the commercial aspects, the societal aspects, the international balancing that needs to be brought to bear, that we and as far as I can tell, it focuses in this group, this team of people who've come together these 3 days, who sort of know how it works, have the opportunity, the context, the depth, and the perception to figure out what we need and to look at the law, not just rigorously and wring our hands and say, isn't it awful, but to understand that it's also in our hands to fix, if a fix is needed, to change anything that needs to be changed. One of the things that I learned somewhat to my surprise when I was involved in thinking about whether we needed to take patent cases away from the regional circuits is that change is not so hard to achieve if you have the right answer, an important answer. So I encourage us to have that very much in mind and to learn from what we're learning these few days from each other, to make this part of the pattern. We are not the only people, of course, who are looking to see how to change and improve and adapt the intellectual property laws to what's happening in the world, to what's happening in technology, the new digital stuff, inventions coming off the cloud, where all you need is a piece of paper and whatever it costs to do the programming, is quite a different pattern of scientific development than what I at least grew up with as a chemist, where after a few years in the laboratory, maybe you can figure out what's happening. So this too is a vital aspect of how the law should adjust for optimum benefit. This is the time, this is the field, and if we focus on vaccines with their powerful societal impact and also international aspects, the opportunities are really quite inspiring. So I encourage us to think energetically and of the possibilities as well as the needs. Maybe I'm overstating, over-imagining the needs, but let's assure ourselves that we're on the right track with the knowledge that if we're not, let's fix it. So that's my message today. So I'm anxious to hear what all of you have to tell us about IP.